in the initial period when I and he were together and we were fighting for this rights, Sonu Nigam was boycotted by the industry. He had no job for 3 years. He had no income for 2 years. Nobody cared for him. And that's where they all depend upon this stream of revenue, which is called live performance. And that's the reason why we all believe that till he is being recognized as Sonu Nigam, till he's actually dancing on the stage, he will earn the money. After that, there is nobody to take care of him during his, his dire circumstances or his negative way of life or the downtrend of life. So that's where royalties and copyright comes into being. As far as cash and check is concerned, I don't think I am authorized to speak on that because I'm not aware of it. And yeah, but yes, you need to pay for an artist whenever he does come for. And अगर ये royalty system शुरू हो जाए इंडिया में, तो ये rates भी कम हो जाएंगे because obviously he's getting it. People will also not. So it's a demand-supply pattern. So that's how the prices get determined. So I thought that is the whole thing. Lakshmi, would you like to sort of state something on this aspect between remuneration and the sort of the royalty system that the artist should be getting? I'll take that.
Yeah, thank you, Sajiji. I also wanted to harp a bit on intermediary liabilities, which is also a subject of discussion today. So, picking off from what Swati had mentioned, yes, they are often careful. They are careful regarding all the interactions on the online platforms, and they have their agreements well in place. However, what we see in practice is that it is very difficult to get a prompt order against the intermediaries, even though the Delhi High Court has eased the process to a very, very great extent. So regarding intermediary liabilities, intermediaries like Amazon, Flipkart, Myntra, you name it, they have liabilities under Section 79 of the Information Technology Act, but then they also quote safe harbor as an exception, saying that they are not liable for anything that is out of their control, something that they do not have control over in their either e-commerce marketplace or their online platform. So the coming in of the intermediary guidelines rules in 2021 has made a large impact, and post the rules, it has been made very clear that the intermediaries should show that they have applied due diligence when adding those infringing goods into their marketplace. So due diligence literally means that they should have provided their customer care number, they should have provided the number and contact of the grievance officer, they should have done a preliminary check and verification of the goods, which is why if you post something for sale on Amazon, they ask you for your trademark certificate, they ask you for your GST number, they ask you for your incorporation certificate if you're private limited or an LLP, they ask you for all the details. So that's the due diligence that the intermediary does. Now, over and above this, there have been a lot of cases in the court where the intermediaries have tried to take a shield behind the safe harbor provision, saying that we have nothing to do with these goods. We're just a portal where the goods are available for sale, and God forbid some of the goods are infringing products. It's beyond our control. So what the courts have done is they have lifted the veil. They have asked them whether they have done their due diligence. And even in the case of Kent RO Systems, the Delhi High Court has very clearly mentioned that intermediaries cannot absolve themselves of their liability, saying that they have nothing to do with the infringing goods. Now, there is a certain lack of speediness in what we would desire as a remedies against infringing products on the online marketplace in India. In other countries like the US, you can obtain a TRO, a temporary restraining order against such goods. And this is the similar provision in India is a Mareva injunction, an ex parte interim injunction, which is given by the court in exceptional cases. For example, Dabur versus Ashok Kumar, there was an ex parte injunction. But in most of the cases, the court waits for the intermediary also to come gives him a fair hearing, and then removes the goods, by which time enough damage has been done. So the court has often in judgments pointed to the fact that if a company notifies the intermediary that there are infringing goods on the marketplace, then the intermediary from its side should remove those goods from the platform. That would be part of the due diligence that it does, pending the final disposal of the dispute between the parties. So this is a position on intermediary liability as it exists in India today.
Correct, but I'm happy that, now that we have the 2021 rules here. But I'll also share with you, because this was way back in 2005 and 6, when Three Idiots was released, and I was in charge of the entire protection of Three Idiots film from piracy. And what I did was, I started the sort of, now it's become a trend in the industry, but I started that off with Three Idiots, the whole system of taking a John Doe order. So after that, now every film takes a John Doe order in the country. But Three Idiots, I think I managed to get a John Doe order, and we prevented piracy of Three Idiots for the Friday, Saturday, Sunday market. And that's how we turned Three Idiots into 150 crore rupees collection during the first 3 days. So at that time, we didn't have the rules, etc. in place as far as intermediary liability is concerned. And I got a John Doe order, and everything was off from the online system in the world. And by doing this also, I was, मैं इसका गुनहगार हूँ, क्योंकि उसमें जो actual copyrighted content भी था, that also went off the air. So there were a lot of effigies of mine burnt in the Delhi University and Ghaziabad border at that time, I remember, because the legitimized content was also taken off by the intermediaries there. So that's the power of having a law and an order in place there. So I think if there are any questions, I would like to now open the floor for questions on this subject, if there are any. Yes.
I have a question pertaining to 17C of the Copyright Act. So, in terms of IT contracts, software development contracts, I come across this issue a lot, wherein a company working for an overseas company here develops something and then claims copyright on it. And the only protection given is that if it's a contract of service, then the copyright belongs to the employer. But proving that is also another head case. I want to ask all of you, what are your thoughts on the current jurisprudence on what is a contract of service, what is a contract for service, and who does the copyright belong to in the end?
Yeah. Lakshmi, would you like to go in first, because you are from the law firm, so
See,
it's your
it
right.
ultimately depends on the agreement between the parties. It is what they agree to. So if it is a contract for service, if that is what they have penned it as, then it remains as such. It's ultimately what the parties agree upon at the outset. So,
Yeah, this is actually a new trend. Let me also pop in. This is this is क्या बोलूं, ज़बरदस्ती वाली बात होती है law courts में, is that a contract for service and by service and for offer service and all that. You see, because the Indian laws has nothing of that sort. This is an American concept which has now come into India. So obviously the courts are also would be seized of this particular way of interpreting a particular contract, as Lakshmi is rightly saying. So there's nothing like that, and you have a real uphill task to prove whether it's a contract for service or off service. So it is there, and it will be based on a case-to-case basis rather than anything. And just to answer your question, yes, the jurisprudence in this is very less. I think it needs to go up, and it will go up in the course of time, I feel. So, because now it has picked up, this aspect about off service and for service is now picked up, so jurisprudence will develop. Yes, Lakshmi.
also as long as your contractual clauses are clear regarding the derivative IP, not the mother IP or whatever contributive IP is there, whatever the derivative IP, who owns it, whether it is a content creator or whether it is a person who commissioned it, as long as the contractual clauses are very clear on that and both parties have a clear understanding and clarity, then I do not think there would be room for much dispute.
Correct. Any other question? Yeah.
So what are the legal mandates for the AI-generated music? So like nowadays the music can be easily generated through AI. What are the legal mandates?
AI generated music is, I would say, is just a trend. It's going to be a fad. There was once upon a time in somewhere in 1990s, cover versions had started. Now there is no cover versions, not much of it. So this is also a fad, which will fade. But as far as the copyright influence of it is concerned and how it's going to impact is that it is nothing but a cover version. AI is a cover version of whatever existing content that will be there. And therefore, the copyright law and its provisions are already in place to deal with that. However, it is but important that AI needs a fence around it. Otherwise, it will go wild. It's going to be a beast for the entertainment industry. It's going to be a beast for the creators and for the owners. And therefore, it needs to be fenced. And I think the government of India is sort of seized of this matter, and we are in the midst of dealing with how to approach the AI thing. So that, of course, you will be hearing some news from the government itself. I'm not authorized to say that just now. Any other questions? But AI is very, very exciting. I love it. So I think AI can be two ways. One way is a negative AI, and the other way is to use it positively. So I think we should all use it positively and not go negatively. Negatively, to just piracy bhi hota hai na. Piracy is the negative aspect of it. The law permits you to use the content, so use it in the correct way, in a legalized way, rather than do it the negative way. So I think that is there. Yes, you are there. You came there. I thought the time is over. So no, over to you. And before I end, you see, copyright